Hi, welcome back to the NearSight and FarSight podcast, brought to you by the investment professionals at InSight. My name is Kevin Taylor. This is the first in a four-part series where we discuss the nuances and power behind having a good, properly managed trust. We've partnered with a local law firm, Schaefer Thomas Mays, in Broomfield, Colorado, and one of their attorneys, Clint Carlisle. This, the first in the four-part series, should discuss the basics of having a good, properly managed trust as part of your full financial plan, and something that every one of our InSight clients discusses as part of their insightful planning process. Clinton, why don't you tell us a little bit about yourself?
My name is Clinton Carlisle. I am an attorney in Broomfield, Colorado. I've been practicing here for a number of years with the firm of Schaefer Thomas Mays. We are a small firm, 6 attorneys, that practices almost exclusively estate planning, which is wills and trusts, and administration after death. So we write the wills and the trusts, we help you create and fund them, and then we can help your beneficiaries administer them at death. Not all law firms do both sides. It's really helpful to have one that does, so they know exactly how this is going to be read, how it's going to be administered, how things are going to really work. I am a Texas native. I moved here for college, and now I live in Erie with my wife and 9-month-old son. So today we're just going to tell you a little bit about the basics of what a will and a trust are. So I'm going to start by just telling you how a will and a trust are different. So there are alternatives for how you can plan your estate. A will is typically a very simple plan in which you just lay out in a document where you want assets to go. A will typically require some court proceeding after your death called probate, whereas a trust is an alternative. It's a much longer document that has much more instruction as far as how you want things to happen, who you want them to go to, and how it should go to them. And a trust, whenever it's properly completed, does not require a court procedure after your death. That's one of the biggest differences. A will and a trust both need to be a comprehensive plan with your financial advisor and your attorney, completing together your documents themselves, the will and the trust, and all your beneficiaries on your retirement accounts and other accounts. Otherwise, they don't flow the way you expect them to. The beneficiaries will ignore what you write in the will and trust, so they have to be aligned together. Same with the titling on your different assets, like your house and any other assets like that.
So, as part of our insightful plan, we make sure that your estate is discussed and documented. But is a will or a trust, are these universally applicable? Should every person have one? What are some of the leading indicators that say I need to absolutely start writing this stuff down?
Most people are going to need a will or a trust. It's not universal that everybody needs a trust, though some lawyers might pitch that. A will is just a very simple way to leave your instructions for what you want at death. There are laws in Colorado and in every state that talk about what happens if you do not have a will or trust. And sometimes they might be exactly what you want. Often it says to your spouse and then to your kids with all of your assets, but keep in mind that you have beneficiaries on your accounts, you have assets that you've titled jointly, and those might not align with what you are expecting if you're just going by what the default is, the law. So to have a will and a trust, it's not only just a document that will express your wishes, it's a time to think about, is everything going exactly the way I want? What's actually going to happen when I die? So it is important to do this every, once in a while. You don't have to do it every year or every month, but every 5 to 10 years, it's a good idea to create a will and then think about it again sometime in the future.
So some of the most common terms that we've heard and we encounter are revocable versus non-revocable or irrevocable. Can you walk us through the differences between those two, when they're best applicable, and who's the right candidate for those types of trusts are?
Yeah, so a revocable trust with an R is the kind of trust you use when you're just planning your estate. You want things to happen at your death. It's a really simple trust you can update anytime Most people update it multiple times before their death just to change instructions of how things are going to go at death. It's revocable, so you can change it. An irrevocable trust, there's a few purposes for one, but typically it's not a simple kind of estate plan. The reasons you might use one is if you're worried about estate taxes, so taxes that happen to usually quite wealthy folks. Right now, it's $11.7 million per person. So if you have more than that, then you might use one of these trusts. Irrevocable trusts can also be used for creditor protection, and purpose is just to leave money to minors and young children. So it's not a type of trust that is usually the main instrument in your plan. A revocable living trust would be kind of the main vehicle for all your assets at death.
So a handful of other terms and titles that we want to discuss so that people know what we're talking about. Who's the executor? Who's a trustee? What types of roles should a person that gets labeled as a trustee or an executor be prepared to serve in that titling as that person?
Yeah, so there's a few roles in estate planning. One is executor. That's the same thing as a personal representative. Colorado just happens to refer to it as a personal representative. Other states use the term executor, so they're interchangeable. That is a person who will open probate if a probate is needed and will administer a will. So they are the main person in a will plan. A trustee, on the other hand, is someone you appoint in a trust document that will handle everything having to do with the revocable living trust or the irrevocable trust. A lot of times they're the same person. There's a lot of overlap, especially if, for instance, you have a revocable trust, but you have some assets that were not put into that trust. You might have both. You might have an executor and a trustee, and if they're the same person, that usually is beneficial. But the types of things those people are going to have to do if they're going to be working with the financial planner, they're going to be working with the attorney quite a bit after your death to marshal up all the assets, gather them into one spot, and distribute them to the beneficiaries. That sounds really easy, but it actually takes quite a bit of time. It's a lot of calling credit card companies and banks and other folks to get them to release the money appropriately and expeditiously and pay creditors. And so it's a big role. But keep in mind, a lot of people worry, well, I want to appoint my parents, but they're so old, I'm worried they're going to be deceased. They're not able to handle this. That's okay. You can appoint them in your documents, and it's not a requirement that they serve. If the time comes and they're not able to handle it, they'll just say so, and the next person in line will handle it. So don't feel like you can't pick someone just because they're older than you or maybe not able to handle it. That's a common misconception.
Hey, Clinton, I have a question for you. When you say put something into a trust, I know a lot of clients make a trust or do a will. Can you help us, our clients, understand what it means to put something into a trust?
Yeah, so when you put something into a trust is very like a business entity, like an LLC. You actually will title assets into a trust, a revocable trust or an irrevocable trust. So take your house, for example. Right now, you probably own it in your personal names. If you create a revocable living trust, you would typically deed your house from your names to your trust name, and that is putting the asset in there, funding it. The purpose of doing that is entirely so that it passes easily at death without needing court probate. Alternatively, you might put an asset into trust using a beneficiary designation. So, for instance, an investment or brokerage account. You can list a revocable trust as the beneficiary of that account, and that account will then pass into your trust at death. Both of those methods are what we would use to create a full plan for you and make sure everything flows appropriately. Because if something is not titled in your trust or put there by beneficiary designation, we can't use the trust to have directions for where it goes. The trust is only as helpful as what goes into it. So it's an important step.
Got it. And I know that a lot of our clients, think that they need a trust, but maybe don't necessarily need one. When you're looking at a client situation, what are some of the things that you look for to say maybe a trust is a good idea? Like for instance, a lot of my clients have property in different states. would it be important for them just to have a trust or a will? Or why would that be important to have a trust in that type of situation?
Yeah, that's a good question. So a trust is a helpful and relatively inexpensive method to own property, but not everybody needs one. And it's not really motivated by how much net worth you have. Like some people think, oh, a trust is only for super wealthy people. I might have heard the term trust fund kid or something like that. Well, trust is really just about what's most efficient for your assets. So one common thing when we almost always will use a trust is if someone owns property in more than one state. So let's say you have a house here in Colorado and a condo in California. That would indicate a trust is going to be very beneficial, because if you don't have a trust, at death, we will open a probate where you resided in Colorado and a probate in California where you also own property. So each state has their own process. Each state has their own probate courts, and we have to open probate in each state in which you own property. So a trust, on the other hand, if we are to title your primary residence and yet condo in California into this trust, we have avoided probate in both states for those assets. So it can be really beneficial when you own multiple states of property and save quite a bit of administration, both court fees and attorney's fees, of doing these probates at death. A trust is also really beneficial when you have younger children and you don't want them to receive everything at once. A trust can have instructions for, I don't want my kids to get assets until they are age X, or maybe in a few different ages, maybe a third at 25, a third at 30, and third at 35. Or you just want to provide some vehicle for creditor protection for the kids after your death for their inheritance. A trust is really good for those kind of things. So it can be really beneficial in some situations, but it's not needed in every situation. Some people just want a really simple plan. They only own a house and maybe a brokerage account. Their kids are adults. They just want everything to go to the kids. And so a will plan will be plenty sufficient and do everything a trust could do for them.
That's fantastic. Thank you very much. If somebody has heard something that they found very important, or they just want to ask you a question, what is the best way for them to reach out and to engage you, Clinton, to get more information?
Yeah, so if people want to contact me directly, like I said, my law firm name is Schaefer Thomas Mays. S is in Sam, T is in Tom, M is in Mary. You can find us at stmlawfirm.com. Phone number 303-469-7367. And my email is on the website. You can find me at ccarlisle, CCARLISLE, at stmlawfirm.com. Feel free to call anytime. Usually we will have a quick intro call with you just to talk about your situation, tell you what our process is like and what expected fees might be. And then we'd have you in the office to look over your existing plan, talk about what options you have for going forward, and design a plan just for you. So it's a long process that you would get to know me pretty well. It takes several weeks for us to know everything about you, talk to your advisors, and create your plan. I'd love to talk with you anytime. Feel free to give me a call. I think the number will be in the description below also.
Thank you very much for your time and expertise, Clinton. Happy to have this partnership with you, and we're happy to move forward. This has been the first in a 4-part series discussing the basics of having a trust. Please look for more topics here on YouTube or on the Investment Podcast. This has been NearSight and FarSight with your investment professionals here at InSight.